Professor Andrew Fitzmaurice from the University of Sydney, Department of History, who does research on early modern British, European, and Atlantic history, intellectual history, the history of political thought, and the history of colonialism. His recent publication is a book titled Sovereignty, Property, and Empire, appeared with Cambridge University Press.
Is appearing.
Is appearing.
It exists on their website, but
okay.
I don't think it's out until October.
Okay.
I cannot test it. Just
And the paper is on Territorium Nullius as a case of sovereign trusteeship, and offers a major critique on the idea of trusteeship, or maybe a call for cautious about the potential abuse of the doctrine.
Yes, I feel like the worst kind of person to ask to a party. But I'd like to thank you, Eyal and Doreen, for bringing me such a very long way, and I feel really privileged to be here, so thank you. So, yes, I have just finished a book on the history of occupation, in which, amongst other things, I criticize a tendency amongst post-colonial theorists to give a deterministic account of the relationship between Western political thought and empire. Some post-colonial theorists, of course, acknowledge that central concepts in Western political thought, such as sovereignty, rights, and the law of nations, were not always employed to justify European expansion. For others, and also for some historians of political thought, it has to be said, such as Richard Tuck in his Rights of War and Peace, for example. So for others, these concepts are structurally disposed to favour the interests of the West, and were developed by canonical thinkers such as Vittoria, Grotius, Locke, and Mill in explicit efforts to justify colonisation and empire. So I found it rather ironic and slightly uncomfortable that when I was invited by Eyal and Doreen to come to this conference, I was struggling to think of instances in which the principles underlying sovereign trusteeship had been employed prior to the 20th centuries in ways that were not implicated in empire in the ways that post-colonial theorists suggest. I found myself arguing almost against the book that I've just completed. In my paper, I examined three ideas underpinning sovereign trusteeship. In some ways, I'm following Eyal's article on this question in outlining those three ideas. So they are: one, the idea of a common human fellowship; two, the universal demands of need and self-preservation; and three, the obligation to take others' interests into account. I began looking at how these assumptions were involved in the debates surrounding the 1884-85 Berlin Conference, in particular in relation to the idea of Territorium Nullius, which I'll speak about later. But I found myself seeking to explain the background to those debates. And so my paper has ranged now from the 16th century to the 19th, with an adjusted title, namely Sovereign Trusteeship and Empire. And what I mean by empire, I'm happy to talk about later. I examine not only the discussions of doctrines and ideas in the writings of jurists and philosophers, but also how those ideas were put into practice in the writings and other acts of agents engaged in colonizing enterprises. But I do not wish to employ a simple division between theory and practice. In common with Lauren Benton, I would argue that the cases in which these ideas were used in justifying particular colonizing ventures suggest that we also need to take a broader approach to what we understand by legal theory. From this broader perspective, sovereign trusteeship appears perhaps less attractive than when it is examined only in the context of canonical thinkers. At best, the claim to have responsibilities to people beyond sovereign boundaries was made by what Evan has described with C.S. Lewis as moral busybodies, and at worst, it was a disingenuous and easily manipulated rhetoric employed to establish relations of domination and dependence. So I'll summarize my observations regarding each of the three ideas that I've examined in my paper. First, common human fellowship. Francisco de Vitoria notoriously introduced the idea of a common human fellowship to examine the justice of the Spanish conquests in the Americas. His account is more ambivalent than many post-colonial theorists would credit, but there is no question that he created a tool that was used by subsequent generations of European colonizers to justify the appropriation of other people's lands. The English promoters of the Virginia Company were amongst the first European colonizers to transform Vitoria's arguments from a defense of the rights of non-Europeans into a case for conquest. Writing the history of travel into Virginia, Britannia, approximately 5 years after the foundation of the first permanent English colony in North America, William Strachey, who had been resident for 2 years in the Chesapeake, asked, "What injury can it be to people of any nation for Christians to come unto their ports, havens, or territories, when the law of nations, which is the law of God and man, doth privilege all men to do so?" He expanded upon this theme by declaring, "The savages themselves may not impugn or forbid the same, in respect of common fellowship and community betwixt man and man." Such claims were almost always followed by the assertion that any resistance to this right of human fellowship was a crime against the laws of nature and could therefore be justly opposed by force. Sanctuary, including the rights of refugees and hospitality to strangers, is another species of these rights of human fellowship that underpin human sociability. Quoting Virgil's Aeneid, Vitoria asked, "What men, what monsters, what inhuman race shut up a desert shore to drowning men and drive us to the cruel seas again?" And of course, the answer to Virgil's question is Australians, because that is exactly what we now do. We shut up a desert shore to drowning men and drive them to the cruel seas again. As you may know, since the change of government in Australia in 2011, there's a change of policy in relation to refugees. Australia had 10,000 refugees a year crossing from Java to Christmas Island, which is an island closer to Java than to the Australian continent, but as part of Australian territory in a way. And of these 10,000 refugees coming each year to Christmas Island, about 500 were drowning. So the Australian government, the new Conservative government, has in great took a very strong sense of its responsibility to people outside its own boundaries, and did not say we don't like refugees. They say we have to save these people from themselves. We can't allow all these people to drown all the time. So we will tow their boats back to Java. In the last 6 months, there hasn't been one single boat that has managed to avoid being intercepted by the Australian Navy and towed back to Java. All this is justified, of course, and that this all happens in international waters outside of the territory of Australia, and is all justified precisely in the terms that I describe in this paper as a recognition of the responsibility of the Australian state to these people. So in Mare Liberum, Grotius cited this same passage from Virgil as proof of as he put it, the sacred law of hospitality. It is a law of nature to welcome strangers, as Vitoria argued, and this right of harbour was decreed amongst all men. The Indians could not therefore deny harbour to the Spanish if they came to their shores, no more than the Spanish or French could deny the same rights to each other. The denial of such rights was a violation of the laws of nature and nations and a just cause for war. Crotius declared, "We know also that wars began for this cause, as with the Magerensians against the Athenians and the Bonians against the Venetians, and that there is also just causes of war to the Castilians against the Americans." Again, for recent scholars, Vittoria provided a sanitized justification for conquest in his discussion of the rights of refuge. But according to Vittoria, the Indians, as he put it, had not denied these rights to the Spanish, and it was the Spanish who violated the laws of fellowship. Once again, however, the probable reason scholars have come to read Vittoria in this way is because subsequent European colonizers exploited the idea of harbour, the rights of strangers, and refuge in order to justify their appropriations of other people's lands. 17th and 18th century English colonizers again exemplified this effort. One of the tracts commissioned as part of the Virginia Company's decision to justify its venture, the anonymous A True Declaration of the Estate of Virginia, posed a series of questions on the justice of the colony, including, "Is it unlawful because we came to them?" To which the author responded, "Is it not against the law of nations to violate a peaceable stranger or to deny him harbour? The Ethiopians, Egyptians, and men of China are branded with a foul mark of sanguinary and barbarous inhumanity for blessing their idols with the blood of strangers." The author portrays the colonizer as the refugee seeking harbour and sanctuary. The people being colonized will be inhumane if they oppose this right. Rejection of that right was a violation of the law of nations and a just cause again for war. The second category of assumptions that underpin the notion of sovereign trusteeship concern questions of need and self-preservation. According to these assumptions, sovereigns are obliged toward humankind to use the resources under their control efficiently and sustainably. Moreover, sovereigns cannot exclude others from the use of resources necessary to their own survival and flourishing, particularly when it comes at little cost to them. Again, when we consider such ideas in relation to the justification of modern European empires, we can begin with Vittoria. Vittoria agreed with the broader implications of the Roman law of occupation, namely that where a people inhabit a territory without exploiting it, that territory should be open to the use of others. So that, as he puts it, all things which are unoccupied or deserted become the property of the occupier by natural law and the law of nations, according to the law Ferae Bestiae, the law of wild beasts. Vittoria hastened to argue, however, that such was not the case with the territories of the peoples the Spaniards had conquered. Although for Vittoria the idea of occupation was used to defend the rights of the peoples conquered by the Spaniards, subsequent European colonizers seized upon the potential in the idea of occupation to describe non-Europeans as not having occupied their lands. Such peoples had not, therefore, fulfilled their natural law obligations to use nature for their own preservation, and they certainly could not oppose other peoples' exploitation of those resources for their own needs. Again, English colonizers were quick to see the potential in such arguments. The ideas synthesized in Locke's discussion of property could be found more than 50 years earlier in John Donne, the poet that is, John Donne's sermon to the Virginia Company in 1622. Donne declared that all peoples must take care to use the resources of the world efficiently. He argued that the whole world, all mankind, must take care that all places be improved so far as may be to the best advantage of mankind in general. And he concluded, in the law of nature and nations, a land never inhabited by any, or utterly derelicted and immemorially abandoned by the former inhabitants, becomes theirs that will possess it. So also is it, if the inhabitants do not in some measure fill the land, so as the land may bring forth her increase for the use of men. The American Indians, as far as Donne was concerned, were not living up to this responsibility to humanity. They did not fill the land, and their territory could accordingly be occupied. The stakes were the preservation of all humanity, and as such, any resistance on the part of the American Indians could be met with force. Implicit in Dunn's and Locke's analysis of human needs was the assumption that we are not born in possession of all that we require for our preservation and flourishing. Indeed, for Grotius, human imperfection underlay the necessity for commerce and freedom of the sea. Nature, he argued, gave, and I quote, all things to all men, but seeing they were barred from the use of many things whereof a man's life standeth in need, it was needful to pass from place to place. In Enlightenment thought, these assumptions were developed into a full theory of human perfectibility, of which Christian Wolff was one of the outstanding exponents. According to Wolff, natural law commands all humans to use their natural abilities to achieve the highest state of happiness and harmony with others. Vattel agreed with Wolff that in addition to pursuing self-perfection and self-preservation, all persons, and thus all states which are fictional persons, should seek the preservation and perfection of others. Just as the 17th century natural law theorists had shown that self-preservation needed others in order to succeed, self-perfection similarly needed the help of others because nobody is born with all that they need in order to achieve perfection. For nations, this meant that they must pursue commerce and society with other nations. Not out of mutual love, as Vittoria had argued, but out of the need to survive and flourish. Wolff's concern with human perfectibility led him to embrace historical progress and enthusiastically to endorse the virtues of civilization. At the same time, he argued that the pursuit of human perfectibility meant that nations should respect the different choices that others made. We're obliged to make our own decisions about how to govern ourselves and restrain our passionate nature, and for this reason each society has to be left to itself to make decisions about how to achieve these goals. According to Wolff, therefore, there is an obligation not only to respect the choice each society makes about its own organization, but also to respect its pursuit of the perfectibility of human nature. The tolerance implicit in Wolff's understanding of human perfectibility was not, however, sustained in all uses of the concept. The pursuit of perfection, the pursuit of union with others in order to become complete, could be employed as a robust form of expansionism, driving the embrace of other peoples through commerce. It could also lead to the crushing of any peoples who impeded such a right and necessity. Vattel agreed to some degree with Wolff's acceptance of the different paths to perfection, but for Vattel, the same pursuit of perfection meant that no people could deny the resources necessary to another people's flourishing. Like Locke, he stipulated that a nation may not appropriate to itself a country which it does not really occupy. All humans are under an obligation to cultivate the earth, and as with colonizing powers, no nation can appropriate more land than they can settle and cultivate. His now notorious conclusion from these premises was that people like the ancient Germans and modern Tatars, who disdained to cultivate their lands, living instead by plunder, deserved to be extirpated as savage and pernicious beasts. War and even the extermination of a people was justified in cases where they impeded others' self-preservation and pursuit of perfection. For Vattel, these conclusions applied to people in the present, not just the historical past. As he ominously concluded at a time of rapid Western expansion in North America, the Indians of North America had no right to appropriate all that vast continent to themselves. Finally, one of the most important assumptions underlying sovereign trusteeship is the notion that as trustees of humanity and not just of national interests, sovereigns have an obligation to take the interests of peoples outside their sovereignty into account. This idea is not, I think as David mentioned this morning, something new. It has a very long historical genealogy. It is a history, once again, that has been closely bound with European expansion and empire. The idea that colonization was undertaken for the benefit of the colonized was a standard claim of 17th and 18th century empires. Typical of such claims was the Virginia Company pamphleteer Robert Gray's declaration, citing Augustine, that war is lawful which is undertaken not for covetousness and cruelty, but for peace and unity's sake, so that lewd and wicked men may thereby be suppressed and good men maintained and relieved. Following the 7 Years' War, many European philosophers and jurists condemned the financial and human cost of empires and began to cast doubt upon justifications of empire based upon appeals to the interests of others. These Enlightenment critiques of empire had a profound impact upon 19th century jurists who condemned the errors of the past and vowed not to repeat them. In France, the jurist, for example, Franz d'Espagnet, echoed anxieties about the injustices inflicted by the pursuit of others' interests, claiming, "The true end of the occupation of territories is the enrichment of the strong to the detriment of the weak. The pretended right to spread civilization had been used to despoil savage peoples of their sovereignty. We know," he said, "with what casualness the powers have treated the rights of indigenous peoples. Neither their institutions, their property, their goods, nor most of all has their sovereignty as states been respected." He continued, "Publicists in favour of respect for their right of sovereignty, such as Vittoria, Soto and Suarez, were without effect in stopping the monstrous abuses of force against the weakest races. This lamentable history was well known," he observed, "and it would seem that the series of horrors observed in the past have not completely ended." He concluded, therefore, that the propaganda of civilization could only justify the nourishment of pacific relations with barbarian countries, including the right of communication and trade. It was precisely this new free trade imperialism that led to a new wave of European domination over non-European peoples. This new kind of empire was once more promoted in terms of the pursuit of the interests of the peoples who were to be its subjects. Its apologists argued that while the new commercial empires brought the benefits of civilization, they did not displace and dispossess non-European peoples as past empires had. These new empires were not to be based upon the seizure of land on a massive scale, as had been the case in the Americas, but upon the seizure only of the one thing that remained unexploited in the non-European world, namely territorial sovereignty. These jurists coined the term, leading into and after the Berlin Conference, they coined the term Territorium Nullius for this doctrine. I think it's important to distinguish, this is probably not the time and place, but to distinguish between Territorium Nullius, Terra Nullius, which is in fact, as Benjamin has argued in previous publications, and I have, Terra Nullius doesn't actually appear in the law of nations until the 1890s. It's not in Roman law. Occupation is, of course, but there is a difference between Territorium Nullius, Terra Nullius, and Res Nullius. We'll talk about that as a separate discussion. So, Territorium Nullius was this justification of the appropriation of territorial sovereignty. Travers Twiss was one of the jurists central to the development of the idea of Territorium Nullius, and he skillfully employed the idea in the justification for the transformation of King Leopold's International Association of the Congo into the Congo Free State. The Congo Free State was a product of both moral busybodies and also of entirely disingenuous legal arguments. As a free state, it was supposedly the embodiment of the new free trade imperialism. It was established in order to free the peoples of Africa from slavery, even as it effectively enslaved and decimated the population of the Congo at a cost in lives estimated in the millions. So in conclusion, there are numerous examples of constructive sovereign trusteeship, particularly in recent decades, and some have been discussed in these last 2 days. In light of this history that I've outlined, this constructive turn in the idea of sovereign trusteeship demonstrates a key philosophical and methodological point in the history of ideas. namely that ideas and concepts and doctrines are tools, and as tools they can be put to various and often contradictory ends. This seems to me to be a positive and a good thing. Having said that, while this conclusion rejects any inherent connection between empire and ideas of human fellowship, self-preservation, and regard for others' interests, I believe that it is necessary for us to be acutely conscious that the history of these ideas is to a large degree a very unhappy one. It is also important to remember that previous generations of jurists believed that they had transcended that unhappy history even as they contributed to it. At least one possible remedy to that problem is to seek fully to understand the tropes whereby seemingly positive doctrines in the law of nations were transformed into rationalizations for expansionism, and to remain aware of that history. Thank you.